So the next panel is discussing what lessons on territorial or universal jurisdiction can be drawn from this historic development from the Holocaust prosecutions. And I'm happy to introduce the chair of the panel. Jennifer Schenzer is working at the moment as a senior officer at the International Nuremberg Principles Academy. She's also a counselor at the international law firm, and she's also producing films with a nexus to justice. So quite a multi-talent, a veteran in the field of ICL, I may say. She joined the coalition, the NGO coalition for the ICC in 1998 and has stayed with them for 6 years and was from 2004 to 2018 a staff member of the International Criminal Court, so I had the pleasure of co-working with her for many years at the OTP. She worked there as a international cooperation advisor. Jennifer holds a Juris Doctor with merits from Columbia Law School and the Bachelor of Science from Georgetown University. She has edited and published a book in the Nuremberg Academy series, the Volume 2, Two Steps Forward, One Step Back, together with Linda Carter. This book I can only recommend to you. It's free for download on the website of the Academy. And with that, Jennifer, floor is yours. Please.
Thank you so much, Klaus. And welcome back, everybody. Welcome to our speakers. And a shout out to Eva, who's around, one of our historians, and I'm very proud that we have two more on the panel. We have first Professor Rebecca Whitman, and then we'll have Professor Annette Weinke speaking. Professor Whitman will start first. Sure. She is an associate professor of history at the University of Toronto, and her research focuses on the Holocaust and post-war Germany, trials of Nazi perpetrators and terrorists, and German legal history. Her most recent work looks at generational memory and shame. And there is much, much more to her bio, but I will leave that for you to read. I'll let her start, and then after she speaks, Professor Weinke will speak, and then we'll call on Mr. Rosenbaum, who is with us remotely in Washington, D.C., and then we'll open up the floor for discussion, and I look very much forward to it. Thank you.
Thank you, Jennifer. Hopefully I can keep you all awake. I've been noting how exciting, but also how different it is to be in person at a full-day conference, and it's late in a beautiful sunny day, but my plan is to shake things up a little bit as one of the historians here who has a very different perspective and will certainly be taking much more of a long view, and be focusing particularly on the history that I research and work on. Because obviously we're preoccupied here at this conference with the question of whether or not there is a way to successfully try the perpetrators of genocide to mete out just sentences. Are the courts, the victims, and society searching for legal justice or for justice to history and memory? For me, the successes and failures of these proceedings as purely legal exercises, as history lessons, which I will talk about a lot, as preventative measures, as meaningful catharses, these are the subject of my interest, but also they're the subject of much debate. And the Nuremberg trials, of course, of the Nazi criminals in the late 1940s remains and I hear it in the discussions today too, the pervasive legal backdrop for the many different sorts of proceedings that were to follow throughout the 20th century, from the Eichmann trial in Israel to the criminal tribunals for ethnic cleansing in Bosnia and for genocide in Rwanda, to the Truth and Reconciliation Commissions in South Africa, and then subsequent trials, tribunals, and so on. Despite developments in international law and universal jurisdiction, as outlined so explicitly in this conference, have moved us, I think, towards better models for war crimes and atrocities being managed on a national stage. And ultimately, that's what we're here to discuss, though current events in Ukraine often do leave me a little bit hopeless about the possibility of justice, no matter how much we dream of it. But this is the long view, and as a historian among lawyers here, I want to draw us back to this kind of age-old debate that exists between our disciplines. What are trials of mass atrocity for? Are they punitive? Are they restorative? Are they preventative? Are they atonement? Are they meant to teach history lessons? International criminal trials attempt to both seek a just verdict and to teach moral historical lessons, whether they admit to the latter goal or not. While some insist that trials should render a verdict and nothing but, others make compelling arguments that trials can in fact galvanize collective interest in the past. But what happens when a nation tries to deal with its own genocidal past using its own criminal code in its state courts? Without the international criminal charges that are now central to our understanding of war crimes trials, without universal jurisdiction, without the concept of crimes against humanity and all, without the supervision of an international community, is it possible to successfully deal with crimes of an unprecedented magnitude? I would say it is decidedly not. So let me take this opportunity to sound a warning bell from history about the perils of national trials and focus on West Germany and then the Federal Republic of Germany, giving examples from the 60s, 70s, and 2000s to see that there is certainly an evolution and improvement, but the burden of precedent and history remain present. So during the mid-1960s, the authorities in the Public Prosecutor's Office in the state of Hesse, West Germany, under the leadership of Attorney General Fritz Bauer, who's a very, very important figure in my world, organized a trial of a group of people alleged to have been responsible for some of the evil, at least, perpetrated at Auschwitz. It was not the first criminal proceeding against Nazi perpetrators in Germany. After the Nuremberg trials of the 40s, West German state prosecution offices began taking up cases in the early 1950s. Only in the late 1950s did these trials really address the final solution and receive widespread public attention. They were not conducted according to the international criminal laws established at Nuremberg, but according to the West German Penal Code. The Germans, along with the Allies, decided to use their own penal code for numerous reasons. Specifically, it had existence since 1871 and was in place throughout the Nazi period. And the existence of these laws made murder illegal throughout the Third Reich and circumvented the harshly criticized use of ex post facto law. After all, in the new German Constitution, Article number 2 was a ban on retroactive law. It's also for this reason that the genocide charge, which was introduced into the German Criminal Code in 1954, could not be applied to Nazi crimes, which had happened a decade before the charge existed. So using this penal code allowed the new democratic West German state to demonstrate its ability to deal with its own past through its own laws. In addition to this, going into, and we can talk about this much more at length later, the murder charge itself, which was used, the manslaughter could not be used by the time of the Auschwitz trial because the statute of limitations ran out 15 years afterwards, so in 1960. And by the way, the murder charge was also up for statute of limitations in 1965, 20 years later. So the Auschwitz trial, which began in 1963, was really under the gun, and all sorts of debates within the parliament led to the erasure of the statute of limitations on murder. But the murder charge itself and its definition for these trials stipulated that the prosecution prove the subjective inner motivation of the defendant. So elements of intent included, for murder, included sadism, lust for murder, sexual drive for killing, treachery, malicious intent, cruelty, and finally base motives, which for the purpose of post-war West German courts was defined as race hatred for Nazi trials, but very rarely used because virtually impossible to prove. There were also debates within judicial circles regarding the definition of perpetration of murder as an objective and subjective act, and ultimately more conservative legal scholars, and in turn the German High Court of Appeals, adopted an entirely subjective definition which determined perpetration entirely by the presence of will, regardless of whether the defendant physically committed the act. The distinction between perpetrator and accomplice in the penal code specified that the primary perpetrator also must show individual initiative and knowledge of the illegality of the act. This just means that defendants could and did use the excuse that they did not know that they were committing a crime. The more defendant, amazingly enough, believed that he claimed that he believed in and identified with the Nazi worldview, the less likely he was to be convicted, despite the fact that the orders of the Nazi state had already been deemed illegal at Nuremberg, and that's something we can also talk about. So the prosecution had to prove beyond doubt that each defendant had acted individually and with personal initiative in order to be convicted of a murder. You can kind of guess where we're going. In the case of bureaucratic or political entities of the Third Reich, where physical acts of murder did not take place, the only unquestioned perpetrators of murder with base motives were the people who dreamt up the Holocaust: Hitler, Himmler, Heydrich. So why was this subjective definition embraced? There's been an explosion of historical research on the West German confrontation with the past in the last few decades, and it points to an undeniable presence of former Nazis, of course, in all parts of public life, in the civil service, the government, academia, press, and most especially the judiciary. Despite the best efforts of the Allies to purge the judicial system of its Nazi members, this seemed to be virtually impossible, as it would have left the justice system without any functionaries. Although if we use the East German state as our comparison, there were ways to rebuild the state without incorporating all the old Nazis into the top levels of power. So this led to a situation where in some places, in Bavaria, for example, in the immediate independence of West Germany, 80% of the judiciary were former members of the Nazi Party, and you had even more in some other places. There was a connection between the jurists and the laws they generated. Legal theorists actively introduced roadblocks to the convictions of former Nazis, and it was intentional, so that jurists could shield themselves from convictions as lawmakers and law enforcers during the Nazi period. I would say this is not necessarily because of pure ideological belief, but it was in order to save their own skin. It's also striking, so for example, that the main jurist heading the Commission for Criminal Law Reform during the 1960s was a man named Edward Dreher, who was the former prosecutor at a Sondergericht, a special court set up by the Nazis that regularly sentenced people to death for small infractions or political beliefs in Innsbruck during the Nazi period. He's presumed to have been responsible for the execution of hundreds of innocent people, and he wrote the most widely used commentary on the criminal law during the 1960s. So surely Dreher's past, and that of so many jurists making reforms to the legal system, played a role in how that legal system was shaped. The Auschwitz trial, which I mentioned, represented a cross-section of criminals who participated in the atrocities at the camp between 1940 and 45. Took place in Frankfurt am Main starting in December 1963. It lasted over 180 days. It involved approximately 400 witnesses and produced 30,000 pages of files, not including the trial record itself. Speaking of recordings, trial recordings, I as a historian can only confirm what Eva so strongly recommended, that these things need to happen. We could talk about it more later, but the Auschwitz trial recordings were meant to be destroyed, and luckily weren't. They provide the basis for our understanding of this trial today. And my research of that trial involved listening to about 500 hours of tape because they were not transcribed. This trial has, of course, emerged as a symbol of West Germany's ongoing confrontation with its past, and yet, as I've argued in the past, the information that the public received was distorted. There was a sincere effort by the public prosecution to indict Auschwitz, to teach lessons about the culpability of all involved in the murder of innocents, but it was entirely hindered by the law as it was defined. And prosecutors had to adhere to rigid interpretations of the murder statute and subjective definitions of perpetrators that, in the end, only condemned those who had gone above and beyond ordered acts of murder. In fact, those who carried out state-ordered genocide were convicted only, if they were convicted at all, as accomplices to murder. The murder of millions in the gas chambers became a lesser crime with a lighter sentence than the murder of one person without orders from superiors. And I would argue that this allowed the German public to sort of chastise and denounce the sadistic excess perpetrators of Auschwitz and to forgive the order followers whose crimes of complicity were never the subject of the trial, the law, or the extensive press coverage from which people obtained their information about Auschwitz. Moving 10 years later, in 1975, marks the beginning of another important trial in Düsseldorf, the Maidonic trial of Campguards, similar kind of trial to the Auschwitz trial, where state attorneys there attempted to bring to trial a representative cross-section of guards from the camp, and to demonstrate that these people had committed horrific acts of shooting and gassing. But the results were also dismal. The vast majority of Nazi defendants would not be convicted of murder because they had not demonstrated this personal will to kill. The 15 defendants were mainly charged with crimes of excess and gruesome cruelty, but the prosecution could prove excess crime only rarely. When there was evidence that the Nazis themselves had disapproved of a guard's actions and had launched an investigation of their own, which was then brought in as testimony, as were these former SS judges who would testify to the sadistic acts that had been committed there. So these crimes deemed murderous in Düsseldorf constituted exceptions to the rule in the Nazi period as well, leading to a kind of perverse echoing of Nazi standards for what was legal and what was not in the Düsseldorf courtroom. The trial was also plagued by legal limitations, endless debates about the eradication of the statute of limitations, a disinterested press, aging and dying defendants, a public who felt that these senior citizens who had lived productive lives for the last 30 years were harmless in comparison to the state enemies on trial in Stuttgart at the same time, which was the Stammheim trial of the Baader-Meinhof gang. And after all, these Nazi defendants had been acting in the name of the state, a perverted state to be sure, but were functionaries. The Stammheim defendants were dangerous. These two trials were conducted simultaneously using the same criminal code and the same charges, but with entirely different legal standards. And I can talk to you more about that later, because that's been a comparison that I've been very interested in making between these two very different trials that happened at the exact same time, but led basically to many arguing that there was what they called a Lex Rapp for the Baader-Meinhof, for the RAF groups, that they had a very specific emergency decrees and changes to laws, and defense lawyers being suddenly expelled for being suspected of supporting a criminal organization, which, of course, as defense lawyers, it looked like they were doing. It was their mandate. The ultimate example of the West German reactionary attitude was the federal attorney's proclamation at the time, Siegfried Buback, that it was a disgrace to act as a defense attorney for the RAF terrorists, which says a lot, that the highest legal official proclaimed the defense of certain defendants to be immoral. He was also, by the way, a former Nazi lawyer. The defendants in Düsseldorf, with the exception of one, were acquitted or had their cases dropped, and the defendants at Stammheim received 4 life sentences each. And of course, it's a very famous story. So how far has Germany come in its judicial reckoning with the past? We can look at more recent examples to see that changes did indeed occur, but not enough. In late November 2009, the State Court of Bavaria opened the trial against John Demjanjuk, who is someone that Eli Rosenbaum is intimately familiar with, and we can talk about that. Demjanjuk was charged with aiding and abetting the murder of 27,900 people at Sobibor. The state attorneys arrived at this number through a process of deduction. It's presumed that Demjanjuk was a guard at Sobibor in 1943, and during that time, as documents show, the same number of people were brought there, mainly from the Netherlands, and murdered. Demjanjuk is a problematic case for many, many reasons. First of all, he's infamous for the sensational trial that happened in Israel 4 decades ago, in which he was tried as Ivan the Terrible from Treblinka, but it was a case of mistaken identity, and he spent 6 years on death row before he was sent back to the United States. And then a case was made against him again when he was in Cleveland, Ohio, and this time he was tried by the Germans, which brings us to another problem with him. He was conscripted by the Red Army. He fought for the Soviets. He was captured by the Germans in 1942. He was then imprisoned as a POW and brought to Trawniki, which was a training camp near the Ukraine border in Poland, set up by the Nazis for POWs like Demjanjuk to do the work of murdering Jews in the Operation Reinhardt camps. And Sobibor was populated almost entirely by Ukrainian SS guards. And so he constitutes a more complex kind of perpetrator than those Germans who joined the SS and worked at camps either because of ideology or in order to avoid serving on the front. Of course, as a participant in mass murder, Demjanjuk should be tried and punished accordingly. Problem lies in perspective and the fact that Demjanjuk spent many more years in prison than many thousands of Germans who voluntarily went to death camps and against whom there was copious evidence. For example, SS Captain Karl Streibe, who was the commander of Trawniki, which was the camp where Demjanjuk was trained. This was a multi-purpose camp, which also served as a forced labor camp for over 6,000 Jews. In October of 1943, after an uprising at Sobibor, an Aktion Erntefest was carried out, harvest euphemistically called, in which all 6,000 Jewish prisoners were shot in a single day. Streibel, as the commander, was indicted by the State Court of Hamburg in 1970, and in 1976 he was acquitted of mass murder. So how is it possible that Streibel could be acquitted while Demjanjuk was convicted as an accomplice? Well, certainly the personnel who constituted the legal system in Munich in 2009 and 10 were not old Nazis trying to protect themselves from incrimination. We're dealing with a whole new generation of jurists, most of whom genuinely want to address the Nazi past and pursue justice. And in fact, in the few Nazi trials that still take place, including the Demjanjuk trial, prosecutors have gotten wise to the fact that it's virtually impossible to get a conviction for perpetration, and therefore do not even indict on that charge. So, for example, since 2013, over 30 Auschwitz guards have been investigated this way, including Oskar Gröning in 2015, and Eli can also speak to this, Reinhold Hanning in 2016, both convicted as accomplices rather than as perpetrators of murder, which they could not be convicted of. Both died during the appeals process, basically. But this perpetuates, of course, the flawed argument that most people who worked voluntarily at death camps were simply accomplices. The state has also made some important adjustments in order to deal with the problem of jurisdiction. Demjanjuk would be tried by the Germans, although he was not German and his crimes did not take place in Germany. He was tried as an Amtsträger, a civil servant who lost his status as a POW because he was paid by the Germans and therefore a member of the bureaucracy. The sentence, 5 years maximum, may seem extraordinarily short in comparison with the magnitude of the crime, accessory in over 20,000 cases, but it's in fact much longer than many former Nazis who were sentenced to in the post-war period. This trial, this sentence, to me is yet another example in a long history of misguided trials, charges, and sentences, and points to a much larger problem in the way that the German justice system from the beginnings in West Germany chose to prosecute Nazis. And it's the historical record of national trials in Germany. And I would argue the law was not the setting in which Germans would come to recognize the wholesale complicity of an entire generation. It would occur through different channels, through earnest historical inquiry, through an explosion of archival research, through scholarship debate, through literature, through artistic representations, through endless discussion. And I would say, and I think this picks up on something that was mentioned at the last panel, that it is in fact the failures of these trials, the deficiencies that in some ways led to more dialogue and more debate, especially amongst those born in the next generation, and to a more wholehearted confrontation with the past. Thank you. I'll leave it there. I could say much more, but I've already gone on long enough.
Thank you very much. Thank you very much for that. And we will have a chance, I think, to touch on any other points you want to raise in the discussion as they come up, but it's very illuminating. And I will turn now to Professor Annette Weinke, who is a professor at the History Department of Friedrich-Schiller-Universität Jena, Germany, and co-director of the Jena Center of 20th Century History. And she has written extensively on themes such as the history of war crimes tribunals, human rights, and international criminal law. And I understand that both professors know each other fairly well, so this is an ongoing dialogue. So we will continue with Professor Weinke, and then we will add in Mr. Rosenbaum and go from there. So welcome and thank you for joining us.
Thanks a lot, Jennifer, for the kind introduction. Can you hear me, or do you have the press button? All right, yeah. Yeah, thanks a lot, and I also want to thank you very much for the invitation. I feel very honored to be here today and to talk to you. Yes, so basically I would like to try to give you some glimpses into the very complicated, sometimes murky history of German post-war Holocaust tribunals, which is already difficult for a historian because there is no clear definition what constitutes a Holocaust trial. This is not so easy because, I mean, the first trials, I will mention that briefly, the first trials were related to German Jews and Austrian Jews and to basically acts which were committed before the beginning of the Second World War in the context of the so-called Reichskristallnacht or the other pogroms. What constitutes a Holocaust trial? This is, of course, a question you can come up with. So I will also start with an example with the Gröning trial. So, and we have heard about this already from Rebecca in November 2016. The Federal Court of Justice, the BGH, upheld a sentence that had been issued 15 months early by a court in Lüneburg, which is a small town in the state of Lower Saxony. In July 2015, the court had convicted the former Auschwitz Campguard Oskar Gröning for being an accessory to the murder of 300,000 Jews. Both the original decision and the BGH rejection of the appeal triggered controversial discussions both on a national and an international level. This was not so much because Gröning's advanced age. The defendant was already in his mid-90s at the time of his conviction. And this was also not caused by his subordinated function in the concentration camps. Gröning was in charge of stripping Hungarian victims of their valuables and money. So the debate was triggered because of the precedent character of the case and the judge's reasoning behind the sentence. 72 years after the end of the Second World War, Gröning became the first person in Germany who was effectively convicted merely for having been part of a killing machinery set up in Auschwitz, although there had been no evidence for his direct and individual participation in the murder. So in its judgment, the court referred to the case of Munir al-Mutasaddiq, who had helped to organize and finance the terrorist 9/11 attack without being directly involved in its execution. So in comparison, another anomaly of this last wave of German Holocaust trials was, if at all, tackled only fleetingly in the public debate. And it was the oddity, as Lawrence Douglas called it, the oddity that after the foundation of West German state in 1949, no single German perpetrator of the Holocaust has ever been prosecuted or sentenced for crimes against humanity or for the crime of genocide. And this is in spite of the fact that the Federal Republic had ratified the Genocide Convention already quite early, in the early 50s. Historiography on the Nuremberg trials and other legal proceedings related to Nazi Germany has expanded significantly in the last 2 decades. So historians have increasingly explored the way in which German courts in West and East Germany adjudicated the Judenmord after 1945. Moreover, they have grappled, or have tried to grapple with the conundrum that Germany's current Holocaust-centered memory culture constitutes something like a stark contrast to its relatively meager balance sheet with regard to Holocaust prosecutions. So only recently, Germany has learned to fully accept the legacy of the Nazi past and has actively incorporated it into an extraordinarily lively memory culture of museums, memorials, and exhibitions, and history books, of course. So against this popular self-image, which often tends to depict Germany as a kind of world pioneer of processing the past, it is crucial to distinguish between the factual history of the post-war trials and its representation in the current memory culture. In a longue durée perspective, one can say that this twisted and very complicated history includes some remarkable results, but also many missed opportunities and dead ends. Even nowadays, it is often overlooked that the vast majority of early German Holocaust trials occurred after 1945 in the 4 occupation zones and in Berlin. In the first years after the Second World War, German courts were obliged to base their jurisdiction on a denazified version of the German Penal Code and on Allied Control Council Law number 10, CCL 10. Adopted in December 1945 by the Allied Control Council in Germany and conceived as an ex post facto legislation, the latter was supposed to give effect to the terms of the Moscow Declaration of November 1943 and the London Agreement of August 1945. It was limited to cases with German or stateless victims and required an authorization by the Allies. CCL 10, which had already been applied in the so-called American successor trials, the Nuremberg successor trials, adapted more or less the 4 provisions of the IMT Charter, which were crimes against peace. Okay, so everybody knows about this. It also included 2 noteworthy alterations. First, it considerably expanded the definition of crimes against humanity, and secondly, it dismissed the so-called nexus requirement of the IMT judgment. The court had prevented the punishment of anti-Jewish crimes in the pre-war period with the argument that crimes against humanity could only be applied when related to the larger crime of aggressive war. So the Allies had conceptualized CCL 10 with the purpose of addressing the specifics of Nazi mass atrocities. Although the Holocaust had not taken a center stage in the Allied prosecution scheme at Nuremberg, only the IMT Charter and CCL 10 offered a sound and suitable legal framework for trying state-sponsored mass crimes of such extraordinary scope and character. It was a new brand of international criminal law because it encompassed the complex chains of command and divisions of labor that had been typical features of the modern German bureaucratic states in the Weberian sense. Nevertheless, CCL10 was met with strong reservations, and you have mentioned this already, strong reservations by most of the West German jurists and legal scholars. They feared that applying the law would violate the bar on ex post facto prosecution, a principle laid down in the West German Constitution, the old imperial penal code, and also Allied occupation law, which was, of course, some contradiction. Another problematic aspect was that it lacked a minimum or maximum penalty frame, which gave the courts an unusually high degree of individual latitude. So against this backdrop, more and more German courts were inclined to circumvent CCL10 by relying exclusively on the so-called Reichsstrafgesetzbuch of 1871. Recently, a scholarly debate has emerged in which it is discussed whether the use of international or domestic law either opened up or limited possibilities for just sentences. In their book, Holocaust Before German Courts, Hans Christian Jasch and Wolf Kaiser show how the early West German judiciary was willing to apply both Allied and domestic law in order to convict acts of street violence against German Jews before and during the war. So there's one case in July 1944, one day after the failed assassination attempt against Adolf Hitler. 3 men forced a Jewish tailor in Berlin, Pankow, to remove pro-Soviet graffiti from a bridge. They abused and tortured the man for 2 hours in front of a crowd of jeering bystanders before throwing the heavily injured victim into the river. In 1951, a court in West Berlin convicted 2 of the 3 perpetrators for crimes against humanity to 15 and 12 years in prison. So the court stated that they had acted out of feelings of deep-seated anti-Semitism and therefore had become guilty of typical racial political persecution according to this law. 2 years later, the federal court in Karlsruhe overturned the verdict because CCL10 was no longer in effect. And after the case was referred back to Berlin, the judges convicted the defendants again to a long prison sentence of 10 years, this time for bodily harm with fatal consequences on the basis of the Reichsstrafgesetzbuch. So according to Jasch and Kaiser, the case demonstrates that even after the foundation of the Federal Republic, it was still possible for courts to throw out sharp sentences for deeds of anti-Jewish street violence, and that German judges were willing to employ CCL10 for accurate assessments of individual guilt. So, however, this positive assessment is relativized when juxtaposed with West German Holocaust trials addressing deportations or mass shootings of German and Austrian Jews in Eastern Europe and the Balkans. Here the courts came to starkly different results. Although the number of victims was of course much higher, the courts tended to focus on the character and the presumed motives of the defendant, so the evocation of a so-called subjective sphere often meant that judges flatly accepted the defendant's justification, that they had either only followed orders or had participated in the final solution, the so-called final solution, under the condition that it would be conducted in a humane manner. Most courts did not challenge the defendant's claim that they had not known about the real purpose of the deportation, because this, in Nazi jargon, this was euphemistically dubbed resettlements or evacuations. In their attempt to undermine the harsh legal consequences of CCL 10, the Allied law was banned and distorted. So the fact that the bourgeois defendants had, I mean, most of them, they were had a bourgeois background, which made a difference. That they had used their functions as district administrators or mayors to enrich themselves with the property of the deported Jews was either reinterpreted as an act to uphold law and order, or to hide one's own dissidence behind a pretended cooperation. On the one hand, these early proceedings refute the generalizing supposition that the late 40s and early 50s were a time when knowledge about the Holocaust was silenced or suppressed. On the other, they demonstrate that factors like the social prestige and the local role of the defendants seem to have mattered more than individual guilt. In the end, only one Gestapo officer got a life sentence, whereas one civil servant was effectively convicted because of his active role in the deportation. So the decade between 58 and 68 was the high time of West German Holocaust trials, and the now famous Ulm trial against the Einsatzgruppen, the special units operating in the German-Lithuanian borderland, was an eye-opener for many Germans and therefore became something like a catalyst of a whole series of similar investigation. So with the foundation of the Central Office of the State Justice Administrations for Nazi crimes in Ludwigsburg, investigations were centralized and systematized, and for the first time since the Nuremberg trials, the collective fate of the Polish Jews under the general government became a focal point of West German prosecutions. Starting with the Stashinsky case of 62, which curiously dealt with the case of a KGB murder by a KGB hitman, killing the Ukrainian nationalist Stepan Bandera here in Bavaria, in Munich. The federal court ruled that from now on, practically everybody except Hitler, Himmler, and Göring had to be seen as an accessory. So this infamous decision paved the way for further jurisprudential inconsistencies in the trials concerning the extermination centers in Chełmno, Belzec, Sobibór, and Treblinka. The defendants, mostly subordinate members of the camp squads, were convicted merely because of their previous functions in the camps. And by contrast, no defendant in the three Auschwitz trials, all three trials took place in Frankfurt am Main between 63 and 68, was ever convicted without any evidence for his individual involvement in acts of murder. Especially the third Auschwitz trial of 67-68 exemplified that those intensive perpetrators who had shown the internal attitude which in the eyes of the BGH predisposed them for acts of excessive violence were treated much harsher than the ordinary members of the camp administration or officials of the Reichssecurity main office, the Reichssicherheitshauptamt in Berlin. Yeah, so I think I will skip the GDR. Maybe we can talk about the East Germany. Makes it even more complicated. With the conviction of Demjanjuk, you've heard about him already. A new and last wave of proceedings against Holocaust perpetrators was started. And it is unlikely that this last wave will considerably change the ambivalent results of West German Holocaust prosecutions. According to recent estimates, out of a total of 14,000 cases, only 6,600 defendants were successfully convicted by the West German judiciary, but not only Holocaust perpetrators. Many more investigations were prematurely closed because of evidentiary problems. So the use of, Rebecca has mentioned this already, the use of the German Penal Code had an exculpating effect for compromised members of the West German judiciary, because it allowed them to evade their former stabilizing role in the Nazi dictatorship. So some authors claim that there might have generally been a higher acceptance for these trials because of the turn from international criminal law to ordinary domestic law. But even if this argument makes sense with respect to West German elites, it is also true that the serious flaws and deficits caused by the neglect of international human rights law by far outweighed the few advantages of national law. Although the underlying legal framework, and this is my last remarks, although the underlying legal framework was crucial, we should not underrate the importance of cultural factors which also impacted on the jurisprudence. So the first and probably most important cultural factor was the almost complete lack of a victim-oriented perspective in West German Holocaust trials. And I think this has not so much to do with the legal framework, but this was more about the general mentality and the attitude towards these trials. Even after the Jerusalem Eichmann trial and the big Frankfurt Auschwitz trials, West German authorities did not seek to establish more intense contacts with individual victims and victims' organizations. Their main focus was on the stabilization of a certain notion of Rechtsstaatlichkeit, not on the legal and psychological needs of Jewish survivors. And this status and limited perspective on West German Holocaust trials was not challenged, I think this is also important, not challenged by representatives of the academia, the media, and civil society. For more than 50 years, the community of West Germany's leading criminal law experts stubbornly refrained from commenting on the verdicts, while most historians in the Federal Republic did not see any particular necessity to study the history of the Holocaust before the early 90s. Considering the exceptional size and difficulty of the task, there is not just one, but a variety of reasons which can explain the relatively meager results of West German Holocaust prosecutions. Thank you.
Thank you very much for that, Professor. And obviously there is so much more detail. Both of you have devoted a lot of time to examining and exhuming some of that. Thank you for sharing that. And I will go on now to Eli Rosenbaum, who was the director of the U.S. Department of Justice Office of Special Investigations from 1994 to 2010, and is now the director of Human Rights Enforcement Strategy and Policy in the new Department of Justice section. And again, he's got a lengthier bio in the brochure. But for now, I will turn it over to Mr. Rosenbaum, and we look forward to hearing from you. Thank you.
Thanks so much, Jennifer. Good afternoon to all of you. It's morning here outside Washington, D.C. It's a privilege to be with you, even if only remotely. As a preliminary matter, I should note that I am, for what I will call logistical reasons that I won't bore you with, I'm presenting in my personal capacity, and hence the views that I'll express are my own, not necessarily those of my employer. The subject of this panel is lessons that can be learned from the history of Holocaust prosecutions. Candidly, as you've, I guess, heard from Professors Whitman and Vanke, this involves deriving lessons from what has largely been a history of failure, and I'll address that too. Yet I remain optimistic, albeit cautiously optimistic, and I retain that element of optimism, despite the fact that although I am a good deal older than my fellow panelists, and therefore I have lived through most of the frustrations that they have described in their presentations. Subsequent to the post-World War II trials at Nuremberg and Tokyo, it has been national courts, not international tribunals, before which all accused Nazi perpetrators and also the vast majority of all persons accused of post-war use Kogan's offenses have been tried. As can be seen quite vividly in the case of Nazi offenders, this abandonment of international accountability mechanisms, which persisted for nearly five decades for human rights violators generally, has been the product of a variety of factors, most especially international geopolitical ones. And relatedly, and this is what I'm going to emphasize, the absence of adequate political will to investigate and prosecute. The Cold War arguably began in Europe even before the Hot War, that is, armed conflict between Axis and Allied forces, came to an end in Europe in May 1945. The landmark and largely successful Nuremberg experiment was soon beset by tensions between Soviet participants on the one hand and those from the United States, the United Kingdom, and France on the other. Soviet insistence that the 1940 massacre in the Katyn forest of more than 20,000 Polish military officers and civilians be proved as a German crime, when in fact it was perpetrated by the Soviets themselves, by the NKVD, was a particularly intense source of discord. Perhaps not surprisingly, there was no appetite after the Nuremberg and Tokyo trials for further international trials in which all of the great powers would participate. And with both East and West assiduously establishing their individual spheres of influence in Europe, with both sides availing themselves of the supposed talents of former German intelligence and military personnel who had served the Nazi regime, and with both sides rebuilding the portions of Germany that they occupied as a bulwark against the other side's military forces, both the Soviet and the Western allies found themselves incentivized, so to speak, to one degree or another, to simply move on. As has often been said, Nazi criminals were among the key victors of the Cold War. A systematic and comprehensive effort could have been launched by national authorities to carry on the efforts that had famously been carried out at Nuremberg to bring to justice the perpetrators of the genocide of European Jews and other ghastly Nazi crimes. But East-West tensions and other factors all but destroyed the political will needed to undertake that necessary law enforcement reckoning in countries that possessed territorial jurisdiction or, to one degree or another, universal jurisdiction. And that, I think, is, alas, the key lesson to be learned from the history of Holocaust prosecutions. Political will is the sine qua non. And it is a much more fragile thing, that political will is, much more fragile thing than many might suppose, as the history demonstrates. The impact of the Cold War in undermining the pursuit of Nazi war criminals is perhaps seen most dramatically in a July 13, 1948 cable, formally classified secret, transmitted by Britain's Commonwealth Relations Office to 7 Commonwealth governments, those of Canada, Australia, and 5 other nations. The cable advised that in the UK's occupation zone of Germany, quote, in general, no fresh trials should be started after 31st August 1948, close quote. And it noted dryly that, quote, this would particularly affect cases of alleged war criminals not now in custody, who might subsequently come into our hands. And then the cable stated bluntly, quote, in view of future political developments in Germany, envisaged by recent tripartite talks, we are convinced that it is now necessary to dispose of the past as soon as possible. Close quote. So already in 1948, the crimes, the history, they were to be disposed of, quote, as soon as possible. A Canadian government report published nearly 40 years later in 1986 disclosed that a senior Canadian official replied by secret cable a month later, offering no comment on the policy decision, but adding a telling observation, quote, I understand, however, that no public announcement is likely to be made about this, close quote. As the 1986 Canadian report noted, and I quote again, and so the matter of war criminals quietly disappeared from the scene, and whether by coincidence or design, in the third of a century which followed, Canada devoted not the slightest energy to the search and prosecution of war criminals. Similar decisions to dispose of the past were made elsewhere. We just heard from my fellow panelists what happened in post-war Germany after responsibility for the cases devolved in the 1950s from the Allies to authorities in the two Germanys. I would add an example. Post-war authorities in Western Germany intensively lobbied the US government to commute the sentences of Nazi criminals who had been convicted before US occupation courts in Germany. Germany's leverage in this campaign was its central importance to the West in the great struggle with the USSR, in which Germany was literally frontline territory. The German intervention was largely successful, with the result that numerous Nazi criminals were released by the United States, including such perpetrators as Martin Sandberger, a former commander in the infamous Einsatzgruppen mobile killing units who had been sentenced to death at Nuremberg in the subsequent trial for mass murder. Sandberger had confessed in court that men under his command had shot to death Jews and communists en masse. So he was released, and he died in freedom just 12 years ago in 2010 in Stuttgart. And by the way, following his release, Sandberger, a lawyer, I'm ashamed to say, by training, found employment as a corporate legal advisor in West Germany. A remarkable German Justice Ministry study published in 2017, and Christoph Severling may be in this conference, and he's one of the co-authors, a study entitled The Rosenberg Files, the Federal Ministry of Justice in the Nazi Era, examined in detail how most Nazi criminals escaped justice in Germany because, as Professor Whitman has said, Nazi functionaries remained in ministry positions and in prosecution and law enforcement offices around the country after the war, because public opinion in Germany was, for decades, hostile to prosecutorial efforts in the Nazi cases, because the German parliament refused to extend various statutes of limitations, and for other reasons. The disposition of the past was perhaps most definitively accomplished in one of Germany's neighboring countries, Austria, where no Nazi criminal has been prosecuted since 1975, fully 47 years ago. An example from beyond Europe. When in 1961, for the first time, an alleged Nazi criminal, a man by the name of Erwin Wix, was exposed in Australia, the Australian Attorney General, Sir Garfield Barwick, went before the Australian House of Representatives and declared that Australia would take no action in the case. Part of Australia's quote-unquote heritage, he declared, was, quote, to enable men to turn their backs on past bitternesses and to make a new life for themselves and for their families in a happier community, close quote. And so, he continued, quote, we think the time has come to close the chapter, close quote. And then he reminded the legislators present, quote, it is truly the year 1961. Imagine that, 1961 is over. My own country's record, of course, must not escape critical scrutiny. In 1979, the Jimmy Carter administration, responding to media and congressional pressure, belatedly created a special unit, the former Office of Special Investigations, or OSI, to locate, investigate, and take whatever legal action might be available against Nazi criminals who had managed to immigrate to the United States. President Carter subsequently acknowledged in a speech that he took this action after decades of what he candidly termed U.S. government inaction in the Nazi cases. Countless accusations had gone unaddressed or inadequately addressed, including those against such perpetrators as New York resident Carl Linnes, who had been exposed in 1961 at the very same time that Erwin Wieks was exposed in Australia. When my office was created in 1979, Carl Linnes was still living in freedom in Long Island, New York. Although U.S. laws didn't confer domestic criminal jurisdiction over crimes that had been committed in Europe before and during World War II, OSI ultimately took significant action. We helped facilitate extraditions of Nazi suspects, and we brought scores of citizenship and removal cases against such persons in federal courts based on fraudulent or illegal immigration and citizenship-related conduct. A variation, I would say, on the universal jurisdiction theme. And we did this in the hopes of delivering the perpetrators to countries, especially in Europe, whose courts possessed the criminal jurisdiction that our courts lacked. What transpired in the 20-year period from 1990 to 2010 is particularly instructive. Those years roughly coincided with the 2 decades immediately following the collapse of the Soviet Union and the resulting opening up of archives in the former USSR that collectively housed the largest quantity of captured Nazi documents extant. That treasure trove of evidence thus became suddenly, almost from our perspective, miraculously available at a time when many thousands of unpunished perpetrators were still alive. Based in part on aggressive investigative exploration and exploitation of those archives, my office, former office, prevailed in more Nazi cases during the 1990 to 2010 period than did all of the other governments of the world combined. 68 cases. This numerical disparity occurred even though the vast majority of Nazi perpetrators were not in the United States, of course, and they weren't in South America either, or Canada, or Mexico. Rather, they were living where they had always lived, in Germany, in Austria, and elsewhere in Europe. In most countries, however, the political will to act just wasn't there. Moreover, when OSI, in which I then served, tried to carry out court orders of removal that it had won, Germany and other countries frequently, very frequently, refused to admit them. We made public a few years ago the fact that John Demjanjuk was actually rejected by Germany when we tried to deport him. And the only way we finally were able to carry out that deportation was working with our German colleagues in Ludwigsburg and Munich. And when they charged him criminally, federal authorities in Berlin, of course, had to change their position. They could hardly refused to admit someone who was now wanted for criminal prosecution in Germany. In addition to refusal to readmit, we found that very, very few extradition requests were ever received from European governments, even for offenders whose Nazi crimes had already been proved in US courts by my colleagues. As a result, more than a few of the perpetrators died in the United States. And of those whom the United States was able to return to Europe, among them a former Nazi concentration camp guard whom we deported to Germany just last year, very few were ever criminally prosecuted. And I hope when we all have our discussion, someone will ask me about the Hans Lipschitz example. Today, at this extremely late date, possibilities for bringing World War II Nazi perpetrators to the bar of justice have nearly come to an end. What Simon Wiesenthal used to call the biological solution to the problem of unpunished Nazi criminals. When we look back at what might have been accomplished over the past 77 years, we see that almost every country in which the perpetrators of Nazi crimes lived since the end of World War II has possessed one or another kind of territorial or universal jurisdiction. So, legal action was almost always possible, be it criminal prosecution, civil action, extradition, or some combination of those. And yet, only a small percentage of the perpetrators of Nazi crimes have ever been prosecuted anywhere. Stated another way, the overwhelming majority of those who committed Nazi crimes against humanity literally got away with murder, indeed, with mass murder. The political will to bring them to justice had all but vanished by 1949. Let me close. If national courts will, in part for reasons of capacity, continue to be the best hope for securing justice in most cases of human rights violations and war crimes, and if, as I have posited, political will to act is the key, the principal question that presents is, what can be done to ensure that political will is in fact generated, and just as important, that it is maintained, that it persists. Based on what we have observed in country after country in the Nazi cases, and certainly in my own country, and especially in studying the kinds of post-war failures of political will that we have seen globally in the Nazi cases, I would submit that some actions, some approaches can be identified as typically being central to success. First, there is a major role to be played by civil society, including human rights NGOs, academics, and organizations of survivors and families of victims, both in promoting public awareness of the crimes and in calling for justice. Second, the media, especially domestic media, must report prominently, unrelentingly, and in detail, even in excruciating detail, on the prosecutions that do take place. And they mustn't succumb to the temptation after a period of time to dismiss ongoing prosecutions as quote-unquote old news that can be relegated to the back pages or even not reported on at all. Parenthetically, I would say we saw that unfortunate evolution, so to speak, of media reporting play out in my own country for many years. When justice is not being pursued adequately, the domestic and foreign news media must highlight this failure, assigning capable investigative journalists to the task of determining why sufficient law enforcement action is not being taken. Crucially as well, influential domestic political figures must be petitioned, even importuned, to take up the cause of fighting impunity. In addition, steps must also be taken to ensure that holdover prosecutors and other officials of a government or government entity that committed the crimes or permitted them to occur without penal sanction do not have the ability to undermine efforts to pursue justice. More generally, manifestations of corruption in national legal systems have to be rooted out. Finally, national prosecutors should, where domestic experience is lacking, consider reaching out to counterparts in other countries who have succeeded in these challenging cases. By doing so, they can help build the requisite skills to develop and prosecute the cases, and they can also enhance their ability to persuade skeptical superiors, skeptical legislators, and skeptical publics that the effort can indeed succeed. I think all of us here today, on whatever side of the Atlantic you are, we can all agree it must succeed because vulnerable peoples everywhere need it to succeed. Thank you.
Thank you very much for that. And as we're getting a little later in the day, I would just like to pick up a few points from the discussion to try to take it forward and to move to audience participation as well. The question has come up a couple of times these last couple days about whether we learn more from the mistakes that have been made than the successes, which is a comfort for those of us who monitor the mistakes or are aware of them. But something also that Professor Weinke mentioned stuck with me, this idea that perhaps the popular imagination or the public imagination of actions that have been taken could differ quite significantly from the actual actions taken. And you and I had talked about a film I watched, which I should have looked up, I don't remember, but I think it came out in the 1990s, a German film called The Nasty Girl, about a girl who has an assignment to write about her hometown and starts to ask questions and sort of realizes that the picture she was presented with growing up was not really so accurate, and everything that came out of that with people not really wanting to talk about it. But I wonder, maybe you could address this a little in terms of this disparity perhaps between the perception of what was done and what was done, and to what degree popular culture also is trying to bridge that gap or trying to call attention to deficiencies that might have been glossed over.
Yeah, thank you. Yeah, so I mean, this girl you mentioned, I met her a couple of years ago, I think 20 years ago in Jerusalem, and I mean, of course, it's a way. I mean, she became very, very famous. What was her name again? I can't remember it now. She's here from Bavaria. I can't remember. She's a middle-aged woman right now. So, I mean, she, in a way, confronted the past in a very unorthodox way, I would say. Anna Rosmus, exactly, yeah, Anna Rosmus. So she confronted the past in a very unorthodox way because, I mean, she just simply didn't care about the fact that there was a Ludwigsburg agency and that there were prosecutors involved in these cases. I mean, she was convinced that it was her obligation as a West German citizen to pick up on these themes and to bring this in the public. And by doing that, she was in a way challenging and questioning a kind of consensus which had evolved in the German society in the 50s, 60s, 70s. So, I mean, this consensus was, I'm talking about now the liberal circles in West German society. The consensus was that there was a kind of labor division between the historians who do serious history, more or less history of the 19th century, early 20th century, but not so much Nazi history, because Nazi history was delegated to non-university institutions, the Institute for Contemporary History in Munich. So this was not part, NS history was not part of the curriculum at the universities. And so you could say that more or less the prosecutors, there was a tiny little unit at Ludwigsburg, they were in charge of bringing up these cases, but this was more or less, delegated to the judiciary, and it was not seen as an overall challenge for the civil society. And so, I mean, she was, of course, extraordinary. And one problem we had, and I mean, because Eli Rosenbaum, he just mentioned that these three success factors, I mean, in a way, there were no victims organizations in Germany because the victims were all dead. This was different. In France, for example, you had the Glasfelds, and they had some stamina because they were, more or less supported by very many organizations. So this was not something which existed in West Germany. But nevertheless, there were a few victims, most of them political victims. I mean, Jewish communists, for example, who were very determined, or ex-communists like Langbein, who were very determined to do something about this. With the media, I would say, I mean, the media were interested, but there was this tendency to focus on a couple of very sensational cases. This was the problem. I mean, they appeared in the courtrooms, but only very briefly. So when the proceedings started, and then maybe when they ended, but there was no continuous coverage of these issues. So, I mean, it was in a way, I mean, what you mentioned, I mean, there were these success factors, but they were shaped by this Cold War atmosphere. So.
Well, for me, it brought back to mind what Reid had said earlier when he intimated that not everybody can be a Karim Khan, but everybody can be a Reid Brody, which I think is probably an exaggeration. I don't think that's entirely true, given his contributions. But I think this idea, asking the question of who is empowered to ask the questions and to take that inquiry forward, and where that space may exist, where there is an impunity gap. And did you want to comment on this, or?
I mean, I could go on all day, but I won't. I absolutely, as you can see, the three of us are very much in agreement with each other about the dismal record, also about the way that the German reckoning with the past comes, and come it has, and it is quite clear that Germany is working through this past pretty much constantly, but this is a phenomenon that did not come quickly, and that I think is just something that I want to reinforce, that this is something that comes much, much later and through different channels than the law. And public perception, I could not agree more, is that, you know, in fact, most people don't really even recognize that there were so many German trials. One thinks of Nuremberg, and that's basically it. But if there was kind of representation of the German trials, it was precisely, as Annette said, focusing on the sadistic excess crimes, which sold papers, which was also the subject and the focal point of the trials themselves, and is also what is most palatable to everybody, is to think, to sort of look away, but and to say, well, we've got these animals, and thank God now the rest of us can move on. And that phenomenon is pretty much a constant post-war phenomenon in Germany. And particular to me, one of the most extraordinary moments comes directly after the Auschwitz trial. It's the commentators on the trial who are enraged by the results, and one of whom is Martin Walser, who after the trial, Peter Weiss also wrote Die Ermittlung, The Investigation, which was a play that was extremely critical of the German confrontation with the past through the law. But Martin Walser, after the Auschwitz trial, was just infuriated by the representation of Nazi crime and said, Auschwitz was not Kaduk's cane, Kaduk being one of these sadists. It was not Boger's swing, Boger being the head of the political department who had created a torture instrument. He said, no, it was gas chambers and mass shootings, and it was ordinary people. Auschwitz was not hell. It was a German concentration camp. And he was infuriated even with the notion of hell as sort of a deserved purgatory. He really ripped it apart. And it's that next generation who starts to rip it apart and starts to ask these difficult questions of their parents. And, I fully benefited from my father doing that to his mother, coming with books about the Holocaust and putting them on her table every summer when we would go and saying, what did you know? And those were terribly ugly confrontations. And in the meantime, sort of the official German discourse has become one of soul searching, the whole question of guilt and shame and what it means to not be allowed to be proud to be German until the World Cup is fascinating. But there is a general representation of this being a country that's dealt with it well. I would say that the official representation is quite different from what still goes on in German families. And there is still that awkward tension and divide talking about grandparents. And speaking of films, where it's also really dealt with very well, one that I think beautifully describes this tortured, arduous, awkward process is called 2 or 3 Things I Know About Him, which you can get online in English too. And it's a son of a very high-ranking Nazi who was convicted, talking about and unearthing his father's relationship to the mass murder of the Jews with his sisters. And within that family itself, the sisters are like, he's my father, I'm not doing this. And this guy won't stop dragging it out. That's where it happens. What you hear from us is it doesn't happen in the courtroom. And I have to just finally say, I do love listening to all of the participants here who are very actively and profoundly committed to this question of justice. No matter how long it takes, as Jeroen said in the last panel, because historians can be very skeptical and cynical about the possibility of it, and I see here many people who aren't, which I actually think is a very good thing.
Can I add something?
Please do. Yes, thank you.
So to pick up on what Professor Weinke said about the absence of say, victim NGOs in Germany after the war, I want to say in part that what optimism I have derives not only from, say, personal experience in working very closely with colleagues at the Zentrale Stelle in Ludwigsburg, who for decades have been extraordinary partners, given us really remarkable assistance, but also when I see what has developed in the human rights world, so to speak, since I was a law student. When I was a law student in the late 1970s, to my recollection, there really was only one major human rights NGO, and that was Amnesty International, and I joined it. There was nothing like the Nuremberg Academy. There were no seminars like this. As I said, Human Rights Watch, Human Rights First, Physicians Without Borders, and on and on. None of those existed. at my law school, which was pretty decent law school, Harvard Law School, there was not a single course, not one, taught on the subject of human rights law. I don't think you'll find a major law school in the Western world today where there are no human rights courses. So I think the attention that is, however belatedly, in recent years now being paid to the problem of impunity, the recognition of the fact that impunity robs the world of the deterrent effect that prosecutions can have, the possibility that prosecutions can literally save lives. That possibility is now increasingly appreciated. That having been said, since I've criticized all the governments, including my own, I will at the same time say that I think for the most part, some exceptions, human rights NGOs have not focused adequately on accountability. That is changing slowly. And I'll give an example, and I will tread carefully here. I have to. We have certain tools that are available to prosecutors in the United States. We have a genocide statute. Didn't become practically enforceable till the new century, but theoretically went on the books in 1988. We have torture and war crime statutes from the 1990s. None of these have retroactive application. We have a child soldier statute. We have a female genital mutilation statute that we enforce. But there are tools that other countries have that we don't have. And I'm not in a position to advocate. I will just say that if I can be forgiven for speaking of NATO, the United States is the only one of 30 NATO countries that doesn't have a crimes against humanity statute. We don't have what's called present in jurisdiction in our war crime statute. I will let others argue about whether we should, but my guess is that the human rights NGO community would favor these things. But I must tell you, the last time that I recall any NGO lobbying on Capitol Hill in Washington for human rights legislation to be enacted was in the late 1970s, when mostly Jewish groups were doing that, and they did it, with success. But other NGOs, I haven't seen them, and even then, our original removal statute that applied in the Nazi cases, which covered participants in Nazi-sponsored acts of persecution, or sponsored by Nazi Germany and its allies in the 1930s and through the war, might have been written to cover persecutors more generally. One would think that that's what the human rights community would have liked to have seen, because there was obviously very little drop-off in persecution, alas, after World War II. But nobody was lobbying for it. A major newspaper editorialized against it. Remember, this is the post-Vietnam period, and said that one man's persecutor is another man's freedom fighter, and so that died. And as far as I know, to this day, no NGO has lobbied for that. So much work to be done.
Thanks for that. Just to follow up on one additional point in relation maybe to the cultural discussion before I put a question for the historians, and also for all of us, in fact. But it brought to mind something that a longtime patron of the Academy said, which was Judge Thomas Bergenthal, that when he wrote his book, Lucky Child, and he went to publishers, they basically told him, we have enough Holocaust stories. Why do we need to publish another one? And of course, if anyone's read his book, it's extraordinary. It speaks for itself. But I wonder if this drive to involve victims more, which Reid and many people have mentioned as well, doesn't also have some roots in those publications of the testimonies. I think of Anne Frank. There was an article in January of investigative journalists still trying to work out who turned her in. Exactly. And that those stories give life, even if that particular person's perpetrators never see the inside of a courtroom. And I wonder how, if those stories don't actually, though, help to drive the involvement of victims in cases and complement it in that way. So I don't know if anybody wants to comment on that.
I'll just briefly speak to that. First of all, the Auschwitz trial is an exception to the rule, and Annette mentioned Hermann Langbein, and he's one of the reasons why, but the other reason why is Fritz Bauer, who I mentioned before too, who was the Attorney General of the state of Hesse, a German Jew who had been in exile during the Nazi period and came back and decided that what was going to happen was that everybody who had worked at Auschwitz was going to be shown to be a murderer. It didn't work out that way, but he was extremely dogged in his desire to make that happen, including bringing in the voices of witnesses. And the Auschwitz trial, through Langbein's work, who's a survivor, as you know, the International Auschwitz Committee was a real grassroots organization of survivors from, globally coming together and being found and interviewed and questioned and bearing witness. And I use that term, bearing witness, to return to what you just said, but they became so instrumental and so important for bringing witnesses to the stand at the Auschwitz trial. I mentioned over 400 of them. In the trial itself, it's probably more like 250, but witness testimonies, it's about 400. And their testimonies, especially in the experience of listening to the recordings of the trial, of course, of profound importance, and are also unbearable and extremely moving, and had such an effect on the courtroom, including on the judge, who you could hear was struggling to figure out how to respond when witnesses would describe, survivors would describe the experiences, the horrors at Auschwitz. Some of those did make it into the press, largely because of the sensational aspect of them. But this is to say that other German Nazi trials did not have this kind of driving force behind it of Fritz Bauer, even though many prosecutors were trying very hard, but lots of witnesses were just so disillusioned by the process, and they didn't want to have anything to do with it anymore. In fact, one of the most important witnesses at the Auschwitz trial, who then also plays a very large role in the film Shoah, named Philipp Muller, who was a Sonderkommando member. When I was doing my research, I wanted to interview him. He still lived in Germany in the 1990s, and he was like, I'm done. I'm not doing this anymore. It doesn't bring anything. And yet, of course, and I think this is one place where Holocaust testimony is so profoundly important, there is a lot of it. There is a lot of bearing witness. It's part of the culture that began in the Warsaw Ghetto of documenting, of insisting upon documenting, and the diaries and the Ringelblum documentation, but others write about them as well too, and bearing witness to what happened is a source of information for scholars, but also I would say for practitioners of law to understand the witness, the victim experience, and there is such a wealth of testimony, but there's also division amongst historians about the value of general memoirs and testimony in comparison with trial testimony, because some of that is much more evocative and visceral, and but testimony plays an absolutely central role to any historian of the Holocaust or a historian of the trials, and if it doesn't, something is wrong.
If I could add two short points. I'm very glad to hear Fritz Bauer's name mentioned. He was a great hero in the struggle for post-World War II accountability, both for Holocaust crimes and other Nazi crimes, in particular euthanasia. But it's also important to mention that although, yes, he was Jewish, he had important help, crucial help in what he did from a German political figure, August Zinn, who I think was the minister-president of the Land of Hesse, particularly in the Eichmann case, where Bauer really did something quite radical, not trusting German authorities to gain custody of, or even maybe to seek custody of Eichmann, who was hiding out in Argentina. He went to the Israelis, and it was many, many years, decades, before it became known that Herzing had authorized that. It didn't happen until he was dead, alas. The other thing I would say is we've heard a lot about failures, and I think we also could do well to try to learn from those comparatively few successes. And the example I'd like to give, because, in part because it hasn't been mentioned, is that of Franz Stangl. That, I think, is an example of the outstanding results that can be achieved when eventually everything is done properly and goes well. So Stangl was the former commandant at different times of both the Sobibor and the Treblinka extermination camps. He ended up in Brazil after the war, and in 1967, he was arrested. Within that same year, he was extradited to Germany. He, by the way, had been registered under his own name with the Austrian consulate in Sao Paulo, but nothing happened on that. Anyway, he was extradited the same year, 1967. That's really fast. And by 1970, he had been put on trial in Dusseldorf and was convicted of some 400,000 counts of murders committed at those, at I believe, Sobibor. And he was sentenced. He got a proper sentence as well, life imprisonment. And he served that after a fashion, as our British colleagues would say, because he died the following year. So it can be done.
Just to, thank you for that. Just to pose another question, and this one for the historians, I think, but for all of us, as I said. When we talk about the importance of testimony, and you've talked about the importance of those recordings from the Auschwitz trial, that there was an archive, that they were kept, even if maybe accidentally or a little bit unintentionally. Perhaps as lawyers, why do we expect the verdict to be the final word? And maybe also, why do we want to know the historical impact of our trial as soon as we're done with it? Or even to have the right somehow to define that for ourselves or to control that narrative. And I wonder, when we look, and they used to talk, and maybe sometimes still at the ICC, about the idea of a completion strategy when they're finished in a situation. It goes towards that question of when do you cross the line from prosecutorial action to contemplation, from creating records to managing or keeping them, going into a more reflective mode or archival mode, and how do you hand that off from the practitioners to the historians? How do you maintain a record sufficient to support that reflection? And I think also reflecting on what some others have mentioned, Rina has mentioned and others about, I think Jeroen as well, about the sensitivity of victims maybe not wanting to be recorded, and maybe they're, as Reid said, maybe needing to see it as something that they own, that they do want to be on the record, confronting their torturer or the person who harmed them. And how do we, maybe separately, and maybe that's a cultural question, how do we communicate the urgency and the importance of continuing to examine that record going forward in whatever way it's done, whether it's in a courtroom or outside of it?
So, I mean, these questions are a little bit, I mean, for a historian, these are difficult to answer because they are more directed towards an audience of legal experts. So actually, I think there's the tendency maybe to overrate the importance of individual trials. I mean, I'm not denying that the Eichmann trial was extremely important, the Auschwitz trial was important, but I mean, if you perceive these developments since the 60s and 70s, I mean, so the fact that there were, that they gave testimony and that there were witnesses included and so on, this didn't cause a shift in the memory culture. I mean, this was a an evolution which happened in a way separately from the trials, and we are still asking ourselves, so what were the decisive events and processes which caused this shift? And this was not only in Germany, but this was a European-wide change which took place, I would say, starting in the late 60s already. Even the East Bloc countries, they came up with this initiative at the UN with regard to the statute of limitations and crimes against humanity. So they were bringing in the Poles. The Poles brought in this this initiative to abandon the statute of limitations. So this was an initiative which was in a way also, of course, induced by the fact that we are approaching the era of detente. There was already cooperation between Ludwigsburg and the Poles, the Polish Main Commission. On the other hand, the 70s were an era where these human rights organizations, where they became really big, and we have KSZE conference, the Conference on Security and Cooperation. So, I mean, these things all happened more or less at the same time, and there was something like a Holocaust consciousness, which, in a way, which did not replace the previous war memory, but it became more and more influential, I would say. And it was also, so the media were part of it. We know that in West Germany, without this Holocaust miniseries, possibly nothing would have happened at all. So this was a major breakthrough, even. I don't like the term breakthrough, but in this case it fits. Yeah. So and these court cases, I would say, they were of course monitored by specialists, but not by the broader public. This became then more and more important. Barbie case in France, but there we already in a different. This was already a different political climate in the 80s. And so there was transnational cooperation. So it's a fascinating question. So what about this fundamental? It was a fundamental shift. Yeah. Mm-hmm.
I think it's a kind of an open question then, but I think as practitioners, we're often focused on what's in front of us. As practitioners, we're often focused on what's in front of us day to day and thinking about the day you file those away and what happens and how they're accessed or so forth. Maybe it's, Irina, do you want to ask a question?
Maybe more a reflection, but I think it's interesting because I think it's important that we also recognize our different roles in this. Of course, in a prosecution, we do think about outreach, we do think about being reachable for the victims. But when it comes to the long-term analysis or looking in a historical context, I think that's for someone else to use the material that's there. Just to give an example in parallel, when quite recently I wrote to the head of the Swedish public service company, the TV company, because there was a publication of videos and material from Bucha, and they were saying that there are documentation that we cannot show on TV of more heinous crimes. And then I emailed her and said, look, I understand we have different roles. I understand that this is not information that can be shared now when it's because it has to do with the security of journalists, of course, at the moment. But what about historical information? I'm guessing that the Swedish public company would have documentation from the Syrian conflict going years back. Maybe they would be able to share that to a structural investigation in Sweden. This is evidence in Sweden. And she gave me a very kind response, but I would respect that, because she said, well, looking at our different roles in this, we are journalists, we're not supposed to do this for these purposes. And I respect that. And also, in the long run, even if they would provide us with historical information that could put future journalists in a different situation, because it might question their impartiality and independence as journalists. So I just think it's important to stick to our roles. We have different roles in this, and try to do what we can, of course, to give you access to information, but maybe not to adjust too much to please other parties. That's just a reflection.
Thanks for that. Were there other questions on the floor? Ricardo?
Good afternoon. I'm Ricardo Izquierdo. I'm part of the team here working at the Academy. And I had a question perhaps more for the... I'm thrilled to have the historical expertise here in the panel. And I was thinking of a topic that was also, in a way, mentioned by Mr. Rosenbaum. And it's about state-sponsored denial of crimes. And Mr. Rosenbaum mentioned the attempt by the Soviets to put the responsibility of the Katyn Forest massacre on the Germans, even in the context of the Nuremberg trials. But you can also imagine other maybe more Kafkaesque situations where you could see a Russian court trying to bring a Ukrainian official to blame them about the supposed genocide happening in the Donbas region, to sort of build the justification for the aggression that they have mounted illegally. And so in that sense, I was wondering if you see any dangers, perhaps, in the use of universal jurisdiction in relation to the protection of the historical memory, especially when you can have also situations like the one we heard earlier today of the Rohingya crisis being tried in Argentina, and the cultural differences that are involved in such processes, and what impact those examples could have in preserving or not historical records of crimes committed, international crimes committed.
I'm not sure if I can answer that as a historian, honestly, because it's never really my role to contemplate when, but I think it's a very important question, when when universal jurisdiction goes horribly wrong, which I think it potentially could in the future and in various different moments. In general, my sense of it is that the example of Germany, first of all, refusing to use the international criminal charges, not really working together with other countries, not showing any interest in trying Nazis as war criminals until, and Eli alluded to this, to the officials at Ludwigsburg, and in particular the lawyers who are there now, and Thomas Walter, who's been so instrumental, are showing an extraordinary amount of will and desire to get every last one of these people. I think that mostly what you see when you don't have universal jurisdiction, yes, there may be some cases where it could be problematic, is much worse. And the German case, again, this question of which Rina alluded to, we should stick to our roles. I agree with it to a certain extent, but I also think it's very important to constantly have the context in the background of, which I asked, what are these trials for? And of course for prosecutors, they're for a certain something, but for the larger public and for the outreach that wants to be done and for potential criminals in the future, there's something much more. And for so many, they end up teaching some form of lesson about what happened in the past and about how that past should be dealt with. And some of those do it much better than others. And this is sort of my argument, that these West German trials do not do it well at all. And believe me, those are prosecutors, and I mean, the judgments that I've read, including the Auschwitz Judgment, the Maidonic Judgment, and so on, you have these judges who recognize the absurdity of the sentences they're giving as they're giving them. In the Auschwitz trial, the judge writes a 900-page judgment and recognizes that it may seem small to, give 4.5 years for 9 counts of accomplice for 9,000 murders each. At some point, it becomes utterly ridiculous. But I'm working within the confines of the law, the way it is described, and we're doing the best we can with that. And, as a historian, you just say, well, that's just not good enough. And you ask yourself, well, why are they working within those confines? Why aren't they trying to change them? And that's where their own desire to save their own butts comes in, that they don't want to widen the definition of murder. They don't want to incorporate the international criminal charges. There are 2 cases of judges coming before the courts, the West German courts, and those are both before 1949. After that, you don't have judges or lawyers put on the stand ever, even though they were the ones who not only created but implemented the laws in fact, what you have is those people writing criminal reform in the 1960s instead. So I don't have a perfect answer, obviously, but I'm a firm believer in the need to broaden the scope.
So I mean, if I understood you correctly, then you are referring to the fact that international criminal law has also maybe a dark side. And I think we all, not only lawyers, but everybody has to be aware of the fact that international criminal law has become a very, very powerful political instrument in the last 3 decades, and I think one of the toxic repercussions of this you see right now in Eastern Europe, and so in my mind, I mean, this is my personal assumption. So in my mind, the fact that that Putin is instrumentalizing these genocide allegations also has a prehistory, and this, I mean, I don't want to engage here in a blame game, but I mean, I think you have to see that, right after the implosion of the Soviet Union, so some of the Baltic states, they incorporated international criminal law in their national penal codes, and they also employed that. So in a way, so international criminal law is not innocent, but it's also a way to reinterpret history. And in this case, it was in a way applied to reinterpret the history of the Second World War, the indigenous collaboration in Nazi crimes. So I mean, there's a clear hierarchy right now. I mean, when you take a look at the museums and Vilnius, for example, there's a clear hierarchy between Stalinist victims and Holocaust victims, and in a way, I would say, international criminal law was used to sanitize the national history. I think lawyers should be aware of this. That this, I mean, if you want it or not, it has very, sometimes very dramatic political implications. So even if it's not used, of course, in a reasonable way, but I mean, the genocide allegation, I mean, all the way during the Cold War, it has been a weapon. There has been some weaponization of the genocide term, and this is still with us.
Sorry, if I could add a lawyer's perspective, or at least this one lawyer's perspective. International law could be misused, and in that regard, it's no different from domestic law, which can be and has been misused in countries from the Soviet Union to you name it. And it's imperative that the good people of the world fight against that, but we can't abandon the rule of law, obviously, particularly for these worst of all crimes, because of the possibility that some prosecutors and their governments will misuse it. We should focus instead on the countless examples that exist of international law being harnessed for good, for obtaining justice, and in fact obtaining justice, and for establishing the real history of what happened in terrible conflicts. I can see even here, looking at my little screen from thousands of miles away, one of my heroes is in the room, Stephen Rapp, who exemplifies that, right? I mean, look what he did at the International Criminal Tribunal for Rwanda, the International Hybrid Tribunal for Sierra Leone, and then when he was ambassador for war crimes issue at the State Department, going all over the world as sort of the Johnny Appleseed of accountability, getting countries to bring human rights violators to justice, and to do it in a transparent and honest fashion. And I think to a great extent, therein lies the hope for the world.
Well, I think if there are not any further questions, we will conclude on that note. But thank you to all the panelists. Thank you for your participation, and to everybody, good night. Thank you.